Good afternoon, everyone. My name is Paula Shapiro, and I am the Associate Director of the Section of Civil Rights and Social Justice. We are thrilled to bring you another program in our six-part series on sexual harassment and assault in the workplace. And it's brought to you by our working group, who's comprised of members from the Section of Civil Rights and Social Justice, the Commission on Women in the Profession, the Commission on Domestic and Sexual Violence, the Commission on Sexual Orientation, and the Young Lawyers Division. We've organized this webinar series to provide an opportunity to hear from experts on different aspects of sexual harassment and assault in the law, to contribute to the ongoing movement sparked by Me Too, media reports, and resignations and terminations of high-profile men accused of sexual harassment and rape. Each of the webinars are live, and a replay is available on our website at www.americanbar.org/CRSJ. The six-part series culminates in the Section of Civil Rights and Social Justice's Showcase program at the 2018 ABA annual meeting in Chicago. It'll be held on August 4th at 10 a.m. at the Hyatt Regency, so if you're in the Chicago area, please join us. During today's program, if you're so inclined, you can ask questions of our panelists by finding the questions box on your right-hand side panel and typing in your questions. You can also access our 5 handouts by locating the handouts dropdown and clicking there. Finally, we'll be sharing a recording of this program and a link to all of the handouts to everyone who is registered so that you can share it widely with your networks. And please feel free to leave us feedback or ask questions to follow up. During today's program, entitled "What is the Link Between Sexual Harassment, Sexual Assault, and Domestic Violence in the Workplace?" you will hear from 2 experts in the field. Katherine Wutchiett is a Skadden Fellow at Legal Aid at Work. As part of LAAW's Work and Family Program and Project Survive, she protects the rights of pregnant women, parents, caregivers, and survivors of domestic and sexual violence to care for themselves and their loved ones without risking their jobs and income through direct representation, policy advocacy, and litigation. Robin Runge is the Senior Gender Specialist in the Equality and Inclusion Department at the Solidarity Center and a Senior Lecturer at the George Washington University Law School. And she's on the council of the ABA Section of Civil Rights and Social Justice and is the chair of the Sexual Harassment and Assault in the Workplace Working Group. She's also the former director of the ABA Commission on Sexual and Domestic Violence. Robin has pioneered the field of gender-based violence in the workplace by creating the Domestic Violence and Employment Project with an Equal Justice Work Fellowship when she graduated from law school, and she has consulted with nonprofit organizations domestically and internationally, and is an expert on ensuring and development of programs to address gender-based violence, sexual harassment, and sexual violence in the workplace and on campus. I'm going to turn it over to Robin. And we're thrilled to have both of you. So thank you for joining us.
Thank you so much, Paula. And I want to note that you were kind of coming in and out a little bit. So I'm going to ask our folks to let us know if they have difficulty hearing us at any point, because we wouldn't know that, right? And so you should feel comfortable to use our wonderful question box for that purpose as well, if there are any technical difficulties. So first, I just want to say I see a lot of friends out there who've called in, so I'm going to try not to be nervous, but thank you. And as Paula said, this webinar really came about as a part of a series that the task force put together, focusing on legal issues related to sexual harassment in the workplace that were coming up as a result of the wonderful reporting from the New York Times and the New Yorker that led to a resurgence of the Me Too movement. We know that Me Too existed prior to last October. It was founded several years earlier, but really picked up speed after the uncovering and the phenomenal reporting on Harvey Weinstein. And then obviously that led to a lot of high profile cases. And then women coming forward and sharing their personal experiences with forms of sexual harassment and actually other related behaviors that I would call gender-based violence and harassment in the workplace that really has helped us as a society grapple with things that we never really understood before. And that's not because we weren't all experiencing it, but it was because we were taught not to talk about it and we weren't talking about it. And so what the Me Too movement really proved is the power and the solidarity that comes about when women are and men are provided the space and the empowerment to speak their truth about their experiences. And one of the things that our webinar series highlighted, and we really wanted to provide this expertise around, is the limitations of our existing legal structure to provide sufficient supports and remedies to victims of sexual harassment, and particularly the forms of harassment and gender-based violence that women were coming forward and speaking about, and that was getting reported in the news. And one of our webinars, for example, really highlighted the narrow definition of sexual harassment as it exists under Title VII, right? And we're going to talk some about that today. And so it was really alarming, and this was picked up in news reports as well, that actually a huge percentage of the really inappropriate and threatening behaviors that women were reporting happening to them in the workplace through Me Too were actually not illegal under our federal law in this country. Now, our state laws are much more generous, but even those have their limitations. And the other set of limitations that one of our other webinars highlighted was exactly that, which is that if assuming even what you've experienced is covered by a state or federal law, you have to navigate a process that is very difficult. And ideally, you need to have a lawyer. And if you're on the federal level, you have to go through an administrative process. So we have all these barriers, right, that make it really difficult to utilize the limited structures that we have that are intended to provide protections, but make them inaccessible to vast majority of low-wage workers in the States, farm workers, right? Latina workers who are janitors in LA who are organizing. And so this highlighted for us a desire for us to bring this webinar to you as a part of this series, because what Katie and I are going to talk about are a series of state and local laws that have been passed in the last 20 years that specifically provide protections to victims of domestic violence and sexual violence in the workplace. And they actually, we believe, can provide you all as practitioners or people interested in this issue with some resources to fill those gaps. They actually address some of the forms of the behaviors that women are coming forward and describing that they're struggling with in maintaining their employment, but aren't covered by our sexual harassment laws effectively. So that's really our goal today, is to bring this information to you about these laws on a state and federal, state and local level that have been passed in the last 20 years. Specifically around domestic violence and sexual violence, but also to highlight for you if you are providing representation to an employer or to individuals, and you're thinking, wow, this may not actually be something that our policy as it's written right now, or the federal law or a state law even provides remedies for, is to look and see if these laws actually might be a good source of support for victims. So that's kind of what we're trying to do today. We want to encourage you, Katie and I do, to ask questions along the way, right? We've got an hour and a half together, and I know what it's like to have a question early on in something and then not hear an answer about it, until an hour later. And in fact, you may not be able to stay with us for an hour and a half. And so if you make sure to use the panel to your right on your screen and type in your questions, we'll make sure to get to those as soon as we can. So now, to kick us off, I'm going to turn it over to Katie, and we have some scenarios, and we're going to use the poll feature, and Paula's going to help us do that. We wanted to just start with some scenarios to get our juices flowing and thinking a little bit about this intersection between domestic violence and sexual harassment in the workplace. And so these great scenarios that Katie's put together are going to facilitate that and get us thinking about that. So go ahead, Katie.
Okay, great. So, as Robin said, a lot of times as employment lawyers, we might not necessarily be thinking about domestic violence or stalking or sexual assault as issues that necessarily pertain directly to our work or things that matter necessarily to our clients. So we want to just kind of think about, what might be domestic violence, what might be sexual assault or stalking. And the reason I'm including all three is a lot of these protections that center on domestic violence, they also include sexual assault and stalking, though of course it depends on, if your state has one of these protections and what that specific section of code says. So our first scenario is Jane works at a motel. Her former partner and roommate Lisa also works there, As Jane is leaving one day, Lisa stops her in the motel parking lot to talk. Jane becomes uncomfortable and tries to leave, but Lisa grabs her hand and won't let her go. Lisa twists her arm, injuring Jane. All right, so here's the time to do the poll and say, you know, do you think this counts as domestic violence? Yes or no? Let's see, and I'm trying to see how this poll works.
So it's instantaneous. It keeps shifting as another person responds, right? So, and we kind of wait for it to get to a settling point because it stops moving once everyone responds. So right now we're hovering around 70% yes and about 30% no, but people are still voting. Keep voting, keep voting.
All right, and I don't see the poll, but that's good.
So we're now at about 75% yes and 25% no.
Okay. Okay, that's great. And you know, it's not always, oh, okay, something that necessarily is clear without looking into it. You know, you might have questions about, you know, does the gender of the people involved matter? Does it matter if, you know, people are currently engaged in a romantic relationship or not? Do they have to have lived together? Does it have to have been something that is romantic? You know, there's a lot of considerations that, you know, maybe haven't come up before for a lot of us in figuring out, you know, whether this does or whether this doesn't qualify.
Right. And I think another one too is whether or not this is an isolated incident, right? Has this ever happened before, right? Or is this the very first time ever that she's done something of this nature, right? Because what makes domestic violence unique is the ongoing power and control dynamics in that relationship, right? So that's another set of questions.
Absolutely. And then for you know, considering what would happen next, you know, there's questions of, you know, is this something that someone has talked with their employer about? You know, are they going to talk with their employer, and what impact that could have?
So we're on to the second poll. True or false scenario one, is this scenario, so we've asked first, is this domestic violence, right? And so the second question is this sexual harassment? So we're hovering around 40% yes and 60% no.
Okay.
Still voting, still voting. I think we're at a stopping point, right? So it's about 40% no, yes, and 60% no, right?
Okay. Yeah, and this can be a, you know, a tricky one too. You know, we have it's near the workplace, but you know, is it on their property? Is that their responsibility in the parking lot? You know, is this, you know, sex-based harassment or gender-based harassment when it is two people who are of the same sex who are engaged beforehand?
And they're both working, they're employees of that same employer, right? They're on the employer's premises, right? So these are all really key to think about. And as Katie was saying before, there are additional facts we'd probably want to know. But I think something we wanted to highlight through this scenario, that it's actually possible for something to be both, right? Both domestic violence and sexual harassment as defined under your jurisdiction state law or under federal Title VII law, right? And this is intentionally drafted in a way to be a little gray, but I think we wanted to highlight kind of the things to think about to make that assessment.
Yeah, and that's a great point too, because you know, what protections are available, what an employer's obligations are, you know, they might be different for domestic violence and sexual harassment, but when they're both there, you know, both of those obligations and protections can kick in. So, you know, you can't necessarily see a scenario and categorize and be like, okay, you know, this is domestic violence, I know what to do. You know, these are all questions you have to have going through your head and analyses you'll have to be doing. So if we move on to the second scenario, so in this case, we have Jennifer, and she just started working as a janitor at an office building. Her supervisor, Jose, is in charge of training her. But Jennifer only speaks Spanish and is reliant on Jose for directions. So he starts flirting with her. Soon he refuses to explain her job duties and to train her unless she has sex with him. She says no, but he threatens that he will tell the manager that she comes in to work late and that she's bad at her job. And eventually she submits. All right, so what does everybody think? Is this sexual violence?
Oh, now people are voting quick. I like it. Lots of like they're on the poll now. I love it. It's like you learn it and then you're in. So we've got about 75% saying yes, it's sexual violence, and 24% saying no.
Okay,
All right.
great. Yeah, and there are some kind of different things to think about in this scenario. So, for something to be, sexual violence or sexual assault, there's a question of, is there force, is there coercion? But that doesn't necessarily have to be something that is physical force. It can be, a different coercive power that somebody has. And when there's an employment relationship, much like in sex harassment, there are these questions too, if the employer is a part of giving someone this power that then they use against somebody, what does that mean as far as their responsibilities to address that? And then
and so just to be really clear, I would consider this to be sexual violence. This is unwelcome, right? She's being forced. As you said, I love the way you frame that, Katie, right? The coercion is clearly because the power Jose has over her, right? Someone may misunderstand that this is a choice that Jennifer is making. She's not making a choice, right? She needs her job, and a person in a position of authority is forcing her to have sex with him against her will. That's what this is, and this is exceptionally common, right? In the workplace in the United States. I've represented many women who've experienced this very thing, and so I want to be really clear that when a woman walks into my office, and if I'm able to create the safe space where she feels comfortable sharing this, and I think that's another really tricky part of this process, because this is not someone coming in and saying that someone said bad things about me and said, as a woman, I suck at my job, right? This is a very intimate thing that someone we hope will disclose to us so we can help them. But if a woman, or when I've had a woman disclose this to me, I actually, as an employment lawyer, am required to, I believe, advise them, as you said, Katie, of their rights to go to the police and report this as a crime. I'm not aware of a jurisdiction in the United States, right, where forced sex is not a crime, and it's called sexual. It's called different things in different criminal codes, right? But my duty and my responsibility, even though she's come to me as an employment lawyer, right, is to make her aware of her right to do that, and to refer her, if necessary, to a lawyer who has more experience than I do in the criminal justice system to advise her about the pros and cons of doing that. If she's undocumented, for example, there are huge risks, especially now, right? And that's, as you said, then the other piece of the puzzle is this a violation of state or federal sexual harassment law, right? So we know that sexual violence, and this fits into the quid pro quo, right? Very clear. But so just to walk through kind of those different scenarios.
Absolutely. And the language piece of it is something that really comes up a lot, in somebody being dependent on somebody else at work, and having that power relationship. When there is a language barrier between an employee and, the other people at work, maybe, like the top manager, it can make it so much more difficult for them to have other ways to reach out, or other avenues if something is going on at work.
Definitely.
Okay. So we have a poll going.
Yeah, so our second poll is the same scenario, right? Is this sexual harassment? So we've discussed, right, that it's already sexual violence, and it looks like 100% of you think this is sexual harassment.
Okay.
Which is good.
A little classic, yeah. Unfortunately, it comes up a lot, so I'm glad that people have caught on.
Yeah.
Okay. All right, and then so moving to our third scenario. So we have Michaela, who works at a restaurant, and her ex-boyfriend sends her threatening texts while she's at work. He starts coming to the restaurant alone to eat his meals, and while he's there, he watches her from his booth. She is uncomfortable, and she's worried that if she tells her manager, that they might hold it against her. All right, so is this sex harassment? All right, so I see we have a poll. How does it
Yeah.
look?
So we've got, it's pretty even right now. Okay, now it's tipping more toward yes. We're at like 57% yes and 43% no.
Okay, great. Yeah, and this is one that can be a little tricky as well. So, there's somebody who she's had this past relationship, who is behaving in a threatening manner to her. But what he's doing at the restaurant, if someone's just observing, if somebody doesn't know what that background is, it might not be something that would necessarily trigger everyone around them as knowing that something is going wrong, that something is threatening. And then there's the question of, even with this background, that something threatening has happened, what role does an employer have in that if, what is going on in their restaurant isn't something that in isolation they would consider to be something that's threatening or some form of gender-based or sex-based harassment or violence.
Mm-hmm.
But, at that same time, if, this is somebody who has been threatening her, of course, as an employee, she's afraid when this is happening. Somebody who poses a threat to her is following her and, being in her space and watching. So
Mm-hmm. In a
there's a lot of,
perfect world, I think we would love employers to create a culture in their workplace, right? So that that employee would feel comfortable coming forward, right? So that it doesn't escalate, right? So that she does feel comfortable doing her job, right? And I think that's a key piece of this discussion that I've been a part of, and I know that the task force I'm a part of at the ABA has been focusing on, and we've been drafting a new policy at the ABA for consideration at the annual meeting, and it's really about culture, right? And I think we can see why maybe even at this moment, even it's not enough to establish sexual harassment as legally defined. There's nothing to stop an employer from having a policy, right, that goes beyond the bare minimum that the law requires and says if something like this happens, right, you should feel comfortable coming forward because we want to support you. That's not something you should have to experience while you're at work.
Absolutely. The benefits of not having employees frightened at work is, something that businesses benefit from. And then also, thinking of, if you're the person who's helping out Michaela or representing her, what kind of notice she might need to provide to her employer to ensure that there is any protection. Because, if this person's just showing up and they're just looking at her and nobody knows anything is going on, if she ends up leaving her job within a couple of days because, it's just too much for her.
Right.
If the employer has no idea what's happening, she hasn't talked to her manager, nothing explicitly, visually harassing has gone on, she's going to be in a much different situation than, if she raises this and tries to seek some kind of relief or support in her work.
Yeah, definitely. Great. Well, I do see we've had a couple of people ask us particularly about scenario number one, Katie, and they want more clarity from us about what our answer is. And I'll go first and then you can join in. I think what I was trying to convey and what I think I heard Katie trying to convey about scenario number one is that in order for me to decide if that's domestic violence, I need more information, right? There's not enough here for me. I need to know more about their relationship. I need to know if this is a one-time occurrence, right? I mentioned that, and I'm going to get into the definition of domestic violence in a moment. But I think what's really critical is understanding that this is going to sound weird, but please bear with me because it's true. There's a lot of violence, frankly, and threatening and difficult things that happen in intimate relationships, right? That we can all think of. Not all of that is domestic violence, right? Domestic violence is a unique set of controlling power and control dynamics that happens over time and involves economic and physical and verbal abuse. And it truly is motivated by power and control and permitted to, and is most often found where there's an inequality in the relationship, and that one person is able to use power and control over the other. That's very different than a relationship that historically has had no strife, and the one spouse loses their job and gets drunk that night and comes home and for the first time ever, hauls off and hits their spouse. That I don't see as domestic violence. Is it a crime? Sure. Is it wrong? Absolutely. Should it not happen? Yup. But that doesn't meet my definition as someone who's been doing work with survivors of domestic violence now for almost 30 years. That's not necessarily domestic violence. And in most jurisdictions, definitions thereof, it would not meet that definition. And so I think I just want to be really clear that I need to know more about Jane and Lisa and their history. And that history can even be since they've separated. Most jurisdictions don't require that you be currently in the intimate relationship with the person who's committing these acts against you in order for it to be domestic violence. So I hope I'm helping clarify a little bit additional information that I would need to know to assess whether or not what's transpiring there is domestic violence. Similarly, I think I need to know a little more information about whether or not it's sexual harassment. And again, I think we also need to piece out whether or not we mean sexual harassment is defined by federal law. I would say, based on my personal experience, this probably would not meet the threshold, and we'll talk about that in a minute, to be sexual harassment under the federal statute under Title VII. But in some state jurisdictions, it might, okay? Because states have different definitions. And in fact, there is a ton of legislation currently pending across the country to amend state laws about sexual harassment in the workplace in response to Me Too. California in particular has a number of pieces of legislation pending. So I hope that's clearer for our folks because people want to know. And Katie, I'll turn it over to you.
Yeah, and that's exactly right. And I'm glad you said that. One thing I just add on to point out is, we would of course need more information, but as far as the question of does this have to have been does this have to be a continuing relationship? Do these people have to be married? Do they have to currently live with each other? In at least some state codes, and I think Robin could weigh in more generally, but my understanding is that, these generally aren't things that are bars because it is about that power relationship, and a lot of the state laws in defining that, they recognize that power relationship can come about in all kinds of different ways. So it doesn't have to necessarily be, what is the first thing that comes into your mind when you think of domestic violence.
Yeah, for example, in DC, you can be roommates, you can be dating, and in fact, the ABA Commission on Domestic and Sexual Violence has charts of every single state's law and how they define domestic violence and the relationship requirements. And if you look at that chart, it's available on their page, resource page. You'll see many jurisdictions say that you don't have to live with or have a child in common or be married to the person who's doing this to you. It can be it can also be in DC. It can be a family member. It can be a grandmother. It can be an uncle. So there's a very expansive understanding as long as those underlying power and control dynamics are present. And I think this is also really relevant when we start thinking about relationships in the workplace, right? And whether or not the relationships in the workplace might be happening even if they're coworkers and they're no longer dating, but these behaviors occur, right? Is it sexual harassment and domestic violence? And if it's both, does that give more possible protections if I'm in a certain jurisdiction?
Absolutely.
All right, great.
So let's move on to talking more about this in the workplace.
Yeah. So thank you, Katie. And so I just see really quickly, yes, the webinar, the slides are going to be shared. The materials are actually available right now as a handout. The PowerPoint is available as a handout right now. And then this whole webinar is being taped and will be available on the Civil Rights and Social Justice section's website along with the materials. So yes, all of those good things. And I venture to say Katie and I are also available in future days if you want to reach out to us individually. So this wonderful graphic that I did not create, one of my sisters in the movement Casey Wagner created this, and it's fabulous. And I think it does a really good job of showing in a visual what we're talking about today. And if there's nothing else you take away from today, I hope that you retain this vision in your mind when you think about these issues, and when someone comes forward to you seeking assistance, again, in your capacity as an individual lawyer representing an employee, or again, if you are counseling employers and developing policies and structures and advising them. And here's the key thing to remember. These forms of gender-based violence and harassment often co-occur, and often the behaviors qualify under our statutes for protections. And so it's really important not to think of a particular set of facts in a silo, right? So as we've just demonstrated, it may be sexual harassment, and it also may be other forms of workplace discrimination, what the person you're talking with describes to you. It also may be workplace violence, and we're not going to talk about that today, but many jurisdictions now have definitions of workplace violence, right? And those definitions on the state level, if there is workplace violence, employers can get protection orders and they can take certain steps to address it. And it's actually in some jurisdictions a crime. We are talking about sexual violence and stalking. And as we described in the scenarios already, you can have a circumstance where the individual who is in the workplace is experiencing something that qualifies as sexual violence, so rape or sexual assault, and is also sexual harassment, a violation of their state and federal laws. And stalking is very similar in that we see a lot of stalking of men and women into the workplace, especially if there's a prior intimate relationship that has, and the individual has tried to leave that relationship, left the home. Often the perpetrator of this behavior, the one place they can continue to find, right, their former partner or their current partner, is the workplace. And so they begin to attack them or stalk them or come after them in the workplace. And then domestic violence, as we've been talking about here, again, for many folks who haven't been in the field, as I have for longer than I care to admit, there can be a belief that that's only happens in the home, right? It only happens in the home. It's contained there. It doesn't go beyond that. It can only happen between people who are married or have a child in common. And what we're going to talk about today is that that's not true. And in fact, we can see domestic violence behaviors taking place in the workplace, and the crime of domestic violence taking place in the workplace, and that can have some options for employees who are experiencing that, and responsibilities for employers to address it. And then the other thing is that even if the domestic violence or sexual violence or stalking is taking place away from the workplace, right? So it's not happening on the premises. It can impact, and if the victim is an employee of your employer, or if the perpetrator is, it's going to have an impact on the workplace. And many states now have laws that have requirements and responsibilities for employers in those circumstances. And so that's what we're going to talk about today. So what is domestic violence? So this is not a legal definition. This is a social definition, for lack of a better description. Katie mentioned this in the context of some of her opening remarks. It's really important to know that domestic violence is defined in the Violence Against Women Act. It's also defined in every single state's differently in their family code, and some in their criminal code. And so you really need to make sure after today that you are familiar with how your state defines domestic violence. So I want to be clear that this definition is not taken from a particular state. But it's intended to provide us with a baseline to understand what we were talking about before, what makes domestic violence unique, and that is that it's a pattern of behavior in which one intimate partner uses physical violence, coercion, threats, intimidation, isolation, and emotional, sexual, or economic abuse to control the other partner in the relationship. So I actually included the term intimate partner in this definition intentionally because I want it to be broader than marital relationships, right? And intimate can mean sex or not, frankly. You can have an emotionally intimate relationship. Some states' definition does include intimacy requirements to establish the relationship requirement, but I was trying to be a little bit broader. But importantly, as I mentioned, if you're in the District of Columbia or in a number of other jurisdictions in the country, you don't have to establish that your client has a sexual or marital, right, or even current romantic relationship with the person committing these domestic violence acts against them for them to qualify for the protections that we're talking about on today's webinar. Oh, so somebody is graciously telling us that the audio is getting worse. Thank you so much, Candy, for telling us. I'm going to hold the mic closer to my face here and hope that helps. Thank you. All right. So what's the connection between domestic violence, I've forgotten a word there, and the workplace? So I started doing this work representing victims of domestic violence in the workplace in 1997. And back in the day, pre-internet, there was actually no data. There was no understanding. We really didn't have a handle on what percentage of people who are currently employed would self-identify as a victim of domestic violence or intimate partner violence. And in fact, as when I got my fellowship out of law school and I was interviewed, they asked me that, and like, do you know how many victims? And I didn't know, and all I could go on was my personal experience working with survivors on hotlines and in shelters to say, they do. I swear they do. Like literally, that's what I said in the interview. Like, I don't have data for you, but I swear they do. And I actually did know at the time, and the numbers have stayed about the same since then, that 1 out of every 4 or 1 out of every 3 women in their lifetime in the United States have self-identified as being a victim of domestic violence. And we know what percentage of women are in the workforce, right? And what percentage of the workforce are women. And so it statistically is impossible, right? And that's just women. I mean, men can be victims as well, and that's really important for us to recognize. But I was thrilled when the Corporate Alliance to End Partner Violence did this, and this is the only survey of its kind that's ever been done. And this was done in 2005. And it found that 44% of employed adults said they personally experienced domestic violence effects on their workplaces. So again, this is not even disclosing that they were themselves the victim, but they maybe were a coworker, right? And saw the perpetrator come into the workplace, and maybe that perpetrator threatened them as a coworker, right? We have, or maybe because the victim was so concerned about her welfare, she was preoccupied when she was at work and unable to complete some of her work tasks, right? Which required a coworker to pick up that slack. We have no idea. There's different ways, right, that it can impact the workplace. 21% of respondents, and this is important, they surveyed men and women, identified themselves as victims of intimate partner violence. And so that is similar to the data I just quoted, which is in the population as a whole, 1 out of every 5, and I said 3, but that's not 1 every 5 or 1 out of every 4 women self-identifies as a victim. And so this number is consistent with that. And then the last statistic that came out of the survey is that 64% of victims of domestic violence indicated that their ability to work was affected by the violence. And the examples I just gave could be of those. So this is really a key thing for all of us to keep in mind, is that, about 1/5 of the workforce right now, 1/5 of people who are going to work every day self-identifying as victims of intimate partner violence. And so that could be domestic violence, that could be sexual violence, that could be stalking, that could be all of those things. And so it truly is a workplace issue. And this survey was very helpful for us when we were trying to get legislation passed on a state level. So these statistics are taken exclusively from federal government studies that have been done over the years, and I actually have all the citations. I'm very careful about that, but we just wanted to give you some more contextualization of the connection between domestic and sexual violence in the workplace. So we know that this is actually from the 1990s, so this is a little dated, and it would be great to get it updated. But in that survey, national survey that was done by a government agency, federal government agency, we know that 25% of rape victims lose their job within a year of the assault. And that could be a rape that took place in the workplace or away from the workplace. And we can imagine why that is, right? Maybe they have need support systems for trauma or post-traumatic stress disorder or anxiety, right? That is triggered because of this very horrific, traumatic, violent event. They may need to, if they're working in the same workplace with the person who's done it with them and they're not able to come forward and speak of it, but they can't continue to work with that person, they may quit their job. I mean, there's just so many circumstances under which they may lose their jobs. And then similarly for victims of domestic violence, we know that the domestic violence has a dramatic impact on their ability to complete their employment, including job loss, not being able to get to work on time. I had clients whose perpetrators would say, oh yeah, I'll totally drive you to work. And then of course they'd be like, oh no, I don't feel like it now, right? Or they would brutally beat them overnight, and then she just couldn't do it. You know what I mean? She couldn't get up in the morning and go to work. So job loss comes in a variety of different forms. It could be my clients were fired because the perpetrator came to the workplace and the employer had what I call the law and order moment and was afraid that everyone was going to get killed and viewed her as the law, and so fired her because of her status as a victim. So there's a variety of different things, and these statistics really help elevate and help us understand that intersection. Katie, I don't know if you want to add anything.
Yeah, no, that's exactly right. The number of ways that domestic violence leads to job loss. I mean, I'm always surprised, but I hear new ones all the time. And, frequently because there's so much stigma that's still connected with it too, people who have suffered an injury or have a black eye or something like that,
Yeah.
they might be finding themselves making excuses to, not be able to go into work that next day because they know the shame that will come with that. But, unfortunately, when they're not at work, this can, like Robin said, impact their performance and make it more difficult going forward.
Yeah. And then the last statistic there is something to keep in mind, which is that the 96 to 98% of employed domestic violence victims experience problems at work related to the violence. So that's a zero-sum game there. That basically means that they may not even see it that way, but they're missing work, and so they're using up all what's left of their vacation or sick time, right? And so they're being put on probation because of performance issues, and maybe they haven't told anybody at work, and so they don't see it as connected, and yet it inextricably is, right? Inextricably. So that's important to keep in mind.
Absolutely.
And then we never want to forget that perpetrators are employees too. And this is really key. I think that in the same way that we've carried with us historically stereotypes about who victims of domestic violence are, we also carried with us stereotypes about who perpetrators are. And so this survey that was done actually by the Maine Department of Labor in the early 2000s, they interviewed perpetrators in a batterers treatment program. And this was really enlightening, right? Because it broke through a lot of, I think, the stereotypes that we have. 78% of them used workplace resources at least once to express remorse or anger, check up on, pressure, or threaten their victim. So that's all time, by the way, when they're not working. And I would argue that more than one of those things is a violation of most workplace policies. So something to keep in mind if you're advising employers. 74% had easy access to their intimate partner's workplace. And 21% of offenders reported that they contacted her at the workplace in violation of a no contact or a protection order, right? So that's really critical. And then the last one is that 70% of the domestic abuse offenders interviewed in this survey lost over 15,000 hours of work due to their domestic abuse arrests. So again, I've had many clients, perpetrators, be bailed out by their supervisor or their boss. I'm not kidding you. That's happened. I can't tell you how many times. And they keep their job open for them. The cost. So when people think about the cost of sexual harassment and domestic violence and sexual violence in the workplace, I think people are really fixated on the impact on the victim. And that certainly is a cost. But people overlook the cost of employing a sexual harasser, a serial sexual harasser, or a perpetrator. These are all lost productivity. It takes time away from your job to do these things if you're employed. And we know that they often are. And so this is the thing that we really wanted to highlight here. Yep, 89.3% of batterers are employed. Yep. So we've been talking about it, but these next slides, and they're in here more really for your reference later on, talk about the things that Katie and I have highlighted in the scenarios and the discussion points thus far, right? That if the perpetrator is someone known to the survivor, right, and they were in a relationship together, they may know where the victim works, they may stalk her at work, they may work in the same place, and all of these things can raise obligations for employers. And those are the things that we want to talk about, and also may manifest as, again, what our legal definition of sexual harassment is, or our legal definition of sexual violence is, or our legal definition of domestic violence. And that they may need time off, right, to heal from injuries, right? They may need time off to relocate. There's a lot of different reasons why survivors of sexual harassment, sexual violence, or domestic violence may need time away. They may want to access the legal system to get a protection order, right, or other supports to protect themselves. And so this just again highlights those examples. So now we've talked about domestic violence and sexual violence, and so now we want to finish out the trio here and talk about what sexual harassment is and highlight that intersection. So I'm going to turn it over to you, Katie, to do these.
Sure. So I imagine many of you are familiar with sex harassment from the wonderful webinars you've seen with Robin in the weeks leading up to this and months. But so federally, there's a law that covers all employees, and it says that you cannot, discriminate against somebody based on sex, national origin, religion, or color. And then that also includes harassment. So when there's something in the workplace that is severe or pervasive.
And the next slide, I think, gives you that.
Okay.
Katie. Yep.
Okay. So sex harassment is a form of discrimination. And if it is severe or pervasive enough to create a hostile work environment, then that's something that is going to be unlawful under Title VII. And there's the questions of whether it's unwelcome and whether it's sexual in nature. And, this test, as I'm sure a lot of you've seen, it can be tricky because, you have something that's pervasive, which, maybe it's not as large of events, but it's ongoing and where that line is. And then the line of, what is it that makes something severe? Does it matter how it feels to the employee, and how does that play out?
Absolutely. And I think just a reminder to all of us, we don't have a federal statute, right, that our statutory language does not include sexual harassment, right? It was defined and interpreted over time with the help of Katherine McKinnon and others in our court system, right, to be recognized as a form of sex discrimination. And as Katie said very well, the criteria here is it must be unwelcome, sexual in nature, and severe or pervasive so as to create a hostile work environment. And as we've alluded to before, there's really these two forms of sexual harassment. There's quid pro quo, which is the sleep with me or you're fired version, which we saw really well demonstrated in the scenario, or it's this constant, regular verbal or nonverbal, right, or physical or psychological behavior. It can be emails or pictures of pornography. It can be actual touching of someone's behind. There's a whole range of behaviors, but that creates an environment, right, that's hostile. Meritor v. Savings Bank is the preeminent case from the late 1980s that established sexual harassment theory as a form of sex discrimination, and that's been in the news a lot lately in the Me Too space. People are going back to that case because, in fact, Ms. Vinson was raped. And that's overlooked in that case often. And the word rape is not used in the opinion. And I want to be really clear about that. But she was forced to have sex, right? Forced to have sex with her boss. And so, again, that gets into our example, right, of sexual assault, right? The intersection of sexual assault, sexual violence, and sexual harassment. And really, our last year of evolution in this work has helped, I think, crystallize for people, because there wasn't clarity before. I can't tell you how many employers I've advised over the years, and employees who had an employee who was raped and didn't know. It wasn't clear, and it wasn't delineated clearly in the policy, the workplace policy that they had, that rape and sexual assault are included in that definition of sexual harassment. And then I also want to say, on a state level, unlike on the federal level, there are state laws that specifically define sexual harassment, right? Not just as a variation of or a form of sexual discrimination. So it's important to know your state law. So this is the really clear intersection. And we're going to talk actually about the intersection with domestic violence as well.
Exactly. And it includes domestic violence. So yeah, just because something, falls into one obvious category, it doesn't mean that it's not all of the above.
So, in fact, as a result of advocacy that myself and some of you on this call, I happen to notice, have done for many years, in 2012, we worked with the EOC to encourage them to issue this guidance document. It's actually a question and answer. It's a sub-regulatory guidance, so I want to be really, really clear here. It's not a reg even, but it's the first time that a federal agency actually spoke about the intersection of domestic violence in the workplace, and really clarified for practitioners like us that the victims of domestic violence have protections under Title VII, which prohibits sex discrimination and sexual harassment, as we've just described under the federal law, and the Americans with Disabilities Act. So the Equal Employment Opportunity Commission enforces both of these statutes, right, and has responsibilities for making sure that they're being utilized appropriately. And what the question and answer document stated is that it clarified that discrimination based on sex stereotypes, right, sex-based stereotypes such as the drama battered women bring to the workplace is prohibited under Title VII. So this is really important, right? So sex stereotyping is a form of sex discrimination that has been evolving, and in fact is how we're increasingly recognizing not just sex-based discrimination, but gender-based discrimination based on sexual orientation and transgender status. And although the federal law doesn't explicitly prohibit discrimination in the workplace based on gender identity or sexual orientation, increasingly we're seeing cases brought by the EEOC, in fact, and others in the federal courts to test and to clarify that gender-based discrimination and sex-based stereotyping in the workplace, right, can form the basis of a sex discrimination claim under Title VII. And that's exactly what this question and answer document is saying, issued by the EEOC. And that is that if an employer is viewing victims of domestic violence in a way, right, that is about stereotyping about who victims are, right, that they are drama and that they won't work hard and they're going to be a mess. This is actually very similar to what we understand about family responsibilities discrimination, right, that's been recognized as well. And it clarifies that firing or otherwise retaliating against an employee who complains about being raped by a supervisor is a violation of Title VII. And so this is really a great document. I encourage you all, the link is on the bottom of this slide. If you're interested in knowing what little guidance there is from the federal government, you're looking at it. But it's very, very helpful. And I do know that people have utilized it in litigation. And then also under the Americans with Disabilities Act, which we're really not going to speak at all about today because of our time limitations, it's important to note that harassment of a victim because of a disability caused by domestic or sexual violence is also a violation of the Americans with Disabilities Act.
Okay.
So wait, we have a question. Wow. So Darren, I'm going to have to follow up with you. His question is there any good data about what kinds of intimate relationships have higher rates of domestic violence? I can provide you with data on that. Very quickly, I want to say that what we do know is that the rates of intimate partner violence in same gender relationships and in transgender relationships are as high as those in heterosexual relationships. And there's actually phenomenal data in the last few years that helps us understand, right, that this is not just a situation with a man and a woman, and it's not exclusive to heterosexual relationships. And that's I think a really key point. And in fact, I think the most recent data I've seen about intimate partner violence in transgender individuals is that it's a little higher. So I'm happy to share that. And then frankly, sexual violence, we know that there are actually higher rates of sexual violence against individuals who are transgender, but that the other rates, and that there's a co-occurrence, right, of sexual violence and domestic violence. So I'll follow up with you.
Okay, great. So in going forward and looking at some of the specific protections that are available for those who are survivors of domestic violence or sexual assault or stalking, there's kind of a number of different protections that can come up and kind of related to the problems that people might have in the workplace. So, as Robin has discussed, when these events are happening, a lot of people need to be able to get job protected time off from work. You know, if they're seeking a shelter, if they're getting medical treatment for something related to the violence they're experiencing, if they need to go get a restraining order, you know, if their job isn't protected during that time, it's going to be so much more difficult for them to make those steps and make those changes that might allow them to escape violence going forward. At the same time, protection against discrimination is really huge. You know, it really isn't uncommon for employers to say that somebody is bringing too much drama and they don't want to deal with it, and to terminate somebody based on that. And the barrier that that can create to reaching out for, you know, that time off or those basic changes at work that somebody needs for their own safety, it can be really troublesome. And then on top of that, there's also accommodations at work. So, you know, getting changes to the way that work is performed, where it's performed, things to make it safer for that individual. And then finally, you know, how to get paid if you take that time off from work. Because, you know, some of these laws you'll see they protect a job if somebody takes time off and if they can't work for some period, but it doesn't necessarily mean that they're going to get paid during that time. So that can be another concern that comes up. And, you know, you'll see some of these laws cover multiple of these areas. And, you know, depending on the state that you're in, some of these might be provided and some of them might not be. But when this situation arises and you're talking with an employee who's facing these circumstances, these are kind of some of the major types of protections and laws to think about going forward.
Yep. So now we want to start talking about these laws that we've been alluding to, and I'm going to start with talking about laws that have been passed in the states in the last 10 or 15 years that prohibit discrimination against victims of domestic violence and sexual violence in the workplace, and in some jurisdictions, stalking. So as of today, California, Delaware, Hawaii, Illinois, Oregon, and New York all have laws. And I want to be really clear, as the slide indicates, these are laws that basically prohibit discrimination based on your status as a victim of domestic violence. You don't have to do gymnastics to prove that it's a form of sex discrimination or sexual harassment. This is purely straightforwardly about prohibiting exactly what Katie was just talking about. I can't tell you how many clients I've had over the years, and I can't tell you how many employers have said, because they don't know, these laws didn't exist, frankly. Well, you know, I know she's going through a lot, but I don't want her here. You know, and they're really very clearly discriminating against my client because of her status as a victim of domestic or sexual violence, right? And as the slides before this have indicated, that can have occurred in the workplace, right? So I have had clients who've been raped at work and the perpetrator gets to stay, but because she's a lower person on the totem pole and she's becoming quote unquote a pain because she complains about it, right? They fire her. So these laws are great tools to use in addition to Title VII, right, that prohibits sexual harassment, because you may have a client who has experienced sexual harassment because the perpetrator is in the same workplace, right, and is conducting themselves in a way that's a violation of that law. And then they may get retaliated against, and that retaliation, if that individual comes forward and seeks redress or remedy from the employer, they may have a claim both under Title VII and under one of these laws, and under their state sexual harassment law, right? If you're in a state like California, right, you're like doing the happy dance. Same thing in Illinois. As a lawyer, we're looking for all the tools that we can bring to bear. And I want to tell you that legislation is pending in other states and on a federal level. We have had legislation pending on a federal level off and on since 1994 that would make it illegal to fire someone because they're a victim of domestic or sexual violence. Our last slide provides a link to Legal Momentum's website, where they actually have an up-to-date fact sheet that lists all the different states' laws regarding domestic and sexual violence, and then you can click on the little link and it will send you to the actual statutory language. It's brilliant. But if you have any questions, because you're in one of these jurisdictions, I know Katie would be helpful in California, and I'd be happy to connect you with people in these other jurisdictions.
Okay,
so Katie, you can go ahead and take this. Yeah.
Yeah, so just to kind of provide some solid examples so you can see, what it looks like from place to place. And we're going to be reflecting back on some of the protections that California has that cover these different areas, so you have an idea of what it might look like. So in California, under the labor code, there's a law that says that an employer cannot discharge or in any manner discriminate or retaliate against an employee because of the employee's status as a victim of domestic violence, sexual assault, or stalking, if they provide notice to the employer of that status or the employer has knowledge. And so this one, it's more recent than some of these other protections. And, it came into play because, we were seeing those challenges at work. We saw clients come to us who had been terminated essentially because they had been a survivor and they needed time off from work. But when the employer's response was, it wasn't, I didn't deny her time off from work. I didn't hold it against her that she needed to go to court. It's just that she is a survivor of domestic violence. That's why we did it. And, it's not necessarily a sympathetic explanation, but at the time, there was a little bit of a hole. I mean, you could definitely make arguments, but just, this straightforward, you're a survivor, this is too much to deal with, it still comes up.
And Katie, I'm remembering that I would say about 6 months before this was passed, there was a very high-profile case out of Los Angeles of a teacher. It actually made the CBS Nightly News. Some of us still watch that. But there was a teacher in LA, right, who was a victim, and she came forward. And this is not uncommon. Employees are struggling with something, and they just want to put their employer on notice. This is where we get stuck all the time. It's out of the goodness of their heart. Sometimes people come forward and say, look, I just want you to know this is what I'm going through. I may need to take some of my leave that I'm entitled to, right? And that's what happened in her circumstance. And then she was fired, and she went to the media, and it was a firestorm that really highlighted the need for this. I remember that.
Yeah. Her kids were expelled from the school too, I think, if I remember correctly.
That's correct. Yeah.
So, yeah. Sometimes the worst example can be at least a sparking point for change.
Yep. And so, as Katie mentioned, in addition to anti-discrimination, which came out of our experiences working with survivors, the other thing that was really clear to us is that sometimes what our clients need is changes to their structure of their workplace to make them safe, right? So that they continue to be productive, stay in that job, right? They want to keep their job often. They want to stay employed because having an independent income is their ability to stay free from a violent relationship. And so in many jurisdictions, and in fact, in most of the jurisdictions in the previous slide that passed anti-discrimination laws, a part of that anti-discrimination law included this language around providing accommodations. And this really recognizes that we should not be penalizing victims for the actions of their perpetrators, right? And that employers do have a duty, an affirmative duty, to keep that workplace safe. And some of you who do disability law may be familiar with the accommodation language, right? Reasonable accommodations comes out of the Americans with Disabilities Act in 1990. That was the first time we saw on a federal level, right, an affirmative duty put on employers, right, to make accommodations for employees who are individuals with disabilities as defined under the statute. So this actually came out of that jurisprudence, right? Those of us who worked on that thought about language that would be effective to explain what we were talking about and provide guidance to employers, language that they were familiar with, frankly, from a different context. I will be honest, I was the minority in that group freaking out a little bit about using the language because there was a lot of litigation in the 1990s about what constitutes a reasonable accommodation under the Americans with Disabilities Act. So I was the one in the drafting meetings going, I don't know, like that has some connotations. But I have to say that we've had a handful of cases that have been reported in the news, in particular in New York City, that have demonstrated that this is a very effective tool. So I really think it's great. And I'll let Katie talk a little bit about California's language.
Sure. So California has language that covers this too. So it provides reasonable accommodations to survivors of domestic violence, sexual assault, and stalking who request them. And there are some examples provided, but what's really great about this type of protection is that it is so flexible. So it just depends on that individual person's needs at work. But by including this in the law, so people know their employer can't retaliate against them for asking for these changes, as intimidating as it still can be, and it is for people, at least it opens the door to having that conversation. So like, for example, there was someone who contacted our office who worked in a store, and in the store they would post the schedule for everybody for the upcoming week. But she had a stalker who was coming and seeing when she would be at work and then showing up when she would be there. So the store posted a decoy schedule for her. So, that's, no cost to them. They just have to print a piece of paper. That's not any large burden on them. But because of that, her stalker wasn't able to find her. It changed from, being able to go there every single time that she was at work to them having, no clue when she would be in her section of the store. So it's really flexible. It just depends on what works for that specific person and what their workplace is like. But it can be a very powerful tool.
Yeah, I mean, I think that's a fabulous example, Katie. And I think I would just again highlight here, this is a good example of where people may see these statutes and think, oh, well, this is for people who are victims of domestic violence or sexual violence or stalking away from the workplace, right? But you could have a client who is sexually sexually harassed. So the more severe forms of sexual harassment, as we've been discussing, are sexual assault and sexual violence. So they may have had a supervisor or a coworker or even a customer, right? Commit acts of sexual violence or stalking as defined in this statute and be entitled to these protections, right? And Title VII doesn't give you reasonable accommodations, right? The federal law that prohibits sexual harassment in the workplace does not place affirmative duties on the employer to provide reasonable accommodations for a victim of rape or sexual assault in the workplace. It doesn't. But if you're in California or Nevada or New York City, and again, we'll have the link to all the different states that have this language included, you could advocate for your client. And if you're an employer in one of these jurisdictions, you may have an affirmative duty, right, to do so. And so to put that in your policy and make sure that those victims of sexual harassment know that again, it doesn't say sexual harassment in the statute. I want to be really clear. It's a little confusing, but it's not, because we're helping clarify it, right? And it's not all forms of sexual harassment. Let me be very clear. It's the more severe ones, right? Sexual violence, sexual harassment are not the same thing. So we have, oh, you can't hear me. I keep letting my thing drop. I'm sorry. So we have a question, which is, I think we're gonna have to follow up on this because I don't know that either Katie or I are experts on the California disability law, though we both know Claudia Center, who we can call up and beg for her indulgence to help us. Someone's asking, does the California law have a similar provision to the Americans with Disabilities Act that a reasonable accommodation can't fundamentally alter the workplace? I don't feel equipped to tell you what the California law says about that. And Katie, I don't want to put you on the spot. So we'll follow up with Darren to answer that.
Sounds good. Yeah, off the top of my head, I wouldn't want to commit, but
I have a guess, but
but like Robin was saying, like one of the things that we see happen frequently is, if somebody has been like assaulted by somebody that they also work with, they might not feel safe working in that same area as that person or working the same shift as that person. So that's something that we see frequently come up where people, want to be working in a different area of the store, or they want to have a different shift. And because, so for these laws, with sex harassment, the employer has, this obligation to investigate and see what happened. But, if it's domestic violence happening outside of the workplace, that's not the employer's responsibility to investigate what happened. Instead, it's if the person provides, some type of certification that they can ask for this accommodation. So this is something that can be helpful, in the meantime. An employer might be, still in the process of doing some kind of investigation into sex harassment, but not to go into the employer's obligations under that and whether or not they should transfer somebody anyways. But, you can come in with a note saying, this is something that I need in the meantime while that's still happening. Okay, and so this goes into more of the details of California's accommodation law. And then the first point is a huge one. So, if an employer isn't aware, they don't have an obligation. So it's important to communicate to employees that, they can seek these changes at work. And, as Robin has said earlier, that can be better for everybody in the business. You don't want your employees to, be feeling threatened, to have their work disturbed. And if they know that they can come forward and that these are available, something can be, avoided in the first place, as opposed to, having somebody come to work or something like that. And the employer, like with disability law, has an obligation to engage in an interactive process with the employee. So if the employee asks for something and the employer thinks it's too big, it's not going to work, then there has to be a discussion going forward from that to make sure that there's a way to accommodate that also works for that business.
Great.
And it does have the same exception where if something is an undue hardship, an employer does have the right to say no to that, but that's subject to that same interactive process. So even if the first ask is too big, there's a path forward to see what can be done to keep that person safe. All right. Moving
Great.
into leave.
Yeah, and so another set of laws that myself and a group of advocates pushed for and helped adopt across the country, starting in the 1990s actually, was again in response to what we saw victims struggling with, and we've alluded to this, the need for time off, so that without fear of job loss, to relocate, to get a protection order, to take steps, right, to define their lives and be safe, especially for themselves and their children. And so as of today, 14 states have passed laws that require employers of different sizes, right? So it varies from state to state. And again, the link at the end will give that detail, to provide different lengths of job guaranteed unpaid. And so that's really important. This leave is unpaid. And so it's not perfect and not everyone can take it, frankly. But it can, for many workers, be the difference, right, between job loss and the ability to leave a relationship that is abusive, and staying in that abusive situation. So these are really can be very, very effective. Illinois in particular, VESA, the Victims Employment Security and Safety Act, is one of the models in the country. But these are all actually quite good. Massachusetts is one of the more recent ones. And so we've listed all the states here, but the citations are available in the link provided in the last slide. And then in addition to that, just wanted to flag for everybody that if your client there's about half of the states, and I've listed a citation for the one in Texas in this slide is for an example, that have something equivalent to like jury duty. You may be familiar from your own personal experience that if you're called for jury duty, your employer doesn't have to pay you necessarily for your time off, but they can't fire you. And this is very similar. If you're subpoenaed as a victim of a crime, in about half of the states in the country, and you present that subpoena to your employer, you can't be fired, right, for going to court and participating in the criminal justice system. And that clearly is inclusive of employees who are victims of domestic violence, sexual assault, and stalking. And so, as I said, these laws vary, but generally speaking, people are permitted to take the leave to go to court to get a protection order, and for themselves and their families, to seek medical attention. And this is critical because the Family Medical Leave Act doesn't cover about half of the workforce because of its requirements in terms of the size of employer, and also the threshold for utilizing it for medical needs requires that you have what's called a serious health condition. And a lot of survivors have medical needs that don't meet that threshold. And so these laws were intended to fill that gap and provide victims with the opportunity to seek the medical attention they need, even if it doesn't meet the threshold under the FMLA, or if they don't qualify, right? They could qualify under this statute, but because they work for a smaller employer or they haven't worked long enough under the FMLA to qualify, they would definitely qualify under this statute. Obtain services from a domestic violence or rape crisis program, and then obtain legal assistance. So these are the examples of permissible reasons for using these, the leave under these statutes. Yes. Oh, yeah, that's right. And some jurisdictions offer job protection for family members who are helping as well. That's true. That's the second wave. I was more involved in the first wave. And as we've described throughout, these statutes also have anti-discrimination language included, right? In California, Katie alluded to that before they got the standalone anti-discrimination provisions for victims of domestic violence based on your status as a victim, they had an unpaid leave, and still do, unpaid leave law that had anti-discrimination protections in it. So an employer couldn't fire or retaliate against someone for trying to access their leave as a victim of domestic violence under this statute. So good protections.
Okay. And just to bring it back to an example, so in California, we have Labor Code Section 230 and 230.1. And so 230, it's like Robin said, it's the same section of law that actually covers, jury duty and going to court as a victim of a crime, but it extends it to seeking relief related to domestic violence, sexual assault, or stalking. So getting a temporary restraining order or injunctive relief or other acts to ensure the safety of the person and then also their children as well. And then in a separate section for employers that are more mid-sized, it does have those protections for more extensive type of services that somebody might need leave for. So seeking medical attention, going to a shelter, psychological care, and safety planning.
It's a great law, if I may say so myself.
Oh, I wonder why. Robin may have had a role.
So then another set of protections, which you may have heard of in the last few years, especially because under the Obama administration, there was a lot of awareness raising and a lot of national attention raised around passing paid sick days legislation. And there's been just unbelievably rapid expansion of the number. I mean, I have to tell you, I looked just again this morning just to make sure another law, I'm not kidding you, another law had not passed in the last 48 hours. That is how quickly states and localities are passing what they're calling paid sick day laws. I think what we want to highlight for you here is these are actually, in my world, we call them paid sick and safe day laws and ordinances because the vast majority of them specifically indicate in their permissible reasons for using the paid sick days that it can be used by an employee who's a victim of domestic or sexual violence or stalking, right, for whatever reasons they need to use it. So very similar to the unpaid laws we just talked about. So we've listed here the states, and I don't even think this is because it's 10 states now. So Arizona, California, Connecticut, Massachusetts, Oregon, Vermont, New Jersey just passed one. So again, it's just happening so fast. And an organization out of New York City called A Better Balance tracks this very carefully and updates a chart on their website literally weekly because they're passing so quickly. But it's really important for all, again, in this theme, right, of thinking about sexual harassment, thinking about sexual violence, thinking about domestic violence. If you have a client who has been horribly sexually harassed in the workplace, including sexual violence or sexual assault, under Title VII, right, our sexual harassment law and state sexual harassment laws, they're not entitled to paid time off to deal with that. They're just not. But they could qualify for it and ask for it under one of these laws. So it's really, or city ordinances. So it's really key for all of you to know that these exist and think about ways to utilize them. And that's in addition to the examples that Katie has been giving about victimization taking place away from the workplace, right? And wanting and needing to take time off to address it. So importantly, these are paid. They're paid for in different, paid by the employer, right? And each jurisdiction has a different list of specific reasons that you can take it. And so they vary slightly, but there's a model, I'll be frank, because I've been involved. There's model legislation that we're all working from, right? And so you tend to see the same language and permissible reasons for taking the leave listed in each one of these laws.
Okay.
Yep, it could be a certification. Go ahead.
Yeah, and then as you'd imagine, California also has a version of these laws by this point. Statewide, it's only been since 2015, but employees who work at least 30 days in a year can receive paid sick leave, and it's at a rate of 1 hour for every 30 hours, and they can take this for many different reasons, even preventative care for themselves, for their family, but it's also for victims of domestic violence, sexual assault, or stalking to take leave for the reasons listed in those past code sections. So if it's something that, their job is protected under those laws, they can use this time to fill that in to make sure that they're getting paid. And it's also against the law for an employer to retaliate based on that.
Yeah, and I know, I always think, because I was a baby lawyer in California, it was the best place, I think, in the world to be a baby lawyer, because you think, wow, like anything is possible here. But I really want to highlight that 10 states now have passed these, and jurisdictions all across the country, including in New Jersey, Minnesota, have passed city ordinances. So don't 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 think that only Californians have those protections, and it's worth going to the Better Balance website and keeping track. So
Yeah.
the other thing we wanted to highlight, and I was involved in this at the Department of Labor in 2015. Then President Obama signed an executive order that established paid and sick leave for federal contractors. And if you don't know, about a fourth of the workforce, between a fourth and the fifth, I've seen 22%, I've seen 25%. Of the workforce works for a federal government contractor in the United States. It's amazing when you think about it, right? That is such a huge percentage of employees in the country, but it really is. It's solidly one-fourth. Solidly one-fifth, and some argue one-fourth of the workforce. And so when this executive order was signed by the president, it suddenly covered a huge swath of employees in the country. And it went into effect in 2000 for all contracts in 2017. I believe there's one more bullet that says that at the bottom. But and it's important to know that employees can earn up to 7 days or more of paid sick leave annually. And the time can be taken, because I was hanging out in the Department of Labor, for the reasons listed here, right? For a victim of domestic or sexual violence or sexual assault, if the employee is, and if their family member is. So if their family member, like the example that we included in the regs, was that if a mother of an adult daughter who's at college is raped, right, she can take this leave to go be with her daughter to provide support to her daughter as she's going through the process of healing and trying to figure out how she wants to address that, right? So the Department of Labor's Office of Wage and Hour enforces this executive order, and they have detailed information on their website that explains which federal government contractors are covered. It's not all, and also the process, and they provide information and fact sheets and all kinds of goodies. But again, this is another good example. The definition of sexual assault and sexual violence and domestic violence in these regulations is not limited to behavior away from the workplace, right? It definitely includes it. But if you're an employee who's been sexually assaulted or experienced sexual violence at the hands of a coworker, customer, or supervisor in the workplace, you could take time off under this statute for that purpose.
And then, so, these vary by state, and some of these are less available, but, as far as income replacements, to think about if you're representing a survivor, or there are other sources of income that might be not targeted specifically to survivors. And this is the same kind of thing, like when we were talking about taking leave under the FMLA or state equivalents, or, asking for reasonable accommodations, or an accommodation of leave under the Disabilities Act, which, we're not getting into because we only have limited time and we're quickly running out. But keep in mind state disability insurance, paid family leave to take care of other family members, and then also unemployment insurance just for when somebody, ends up needing to leave their work. And depending on the state, there are some locations where if somebody leaves work because of domestic violence or reasons related to that, the employer won't be charged for the unemployment insurance, so won't come out of their account, to try and prevent employers challenging people's applications. So another thing to keep in mind and potentially look into when it comes up.
Thank you. I think that's really critical. One thing, we've got a question, is someone's asking for the name of the executive order, so I just want to answer that quickly. The executive order is, there's a number, it's 13706. I'm embarrassed that I've memorized this, but whatever. And it's called Establishing Paid Sick Leave for Federal Contractors. and it was signed on September 30th, 2016. It was signed in 2015, but the final rule regulations were issued by the Department of Labor on September 30th of 2016. And those are all available on, as I said, the Wage and Hour website. If you Google, Department of Labor, wage and hour, and sick leave, you'll get to this page. It has frequently asked questions and fact sheets and posters and detailed information. So.
Okay. And then just another thing to highlight in this will, of course, vary by state. But, one of the things that we kind of keep coming up against is that, if somebody's experiencing this, a lot of these protections are only triggered and only available if the employer knows about it. If they're not aware this is going on, then, they're not going to have that obligation to make a change at work. But, that can be a very serious barrier for individuals. So depending on the state and their specific laws, there might be, sometimes ways to get around it. So, we're not getting into these areas because it'd be a whole deep dive, but, like some accommodations can be available for disabilities as opposed to because of domestic violence. So that can be a way to work around, or for taking time off, sometimes things can be phrased as paid sick days, and certification that an employer can request and that's required depends by state and ordinance as well. Also, FMLA, it doesn't apply to everybody, but if it does, that can be a way to get time if maybe someone is seeking time off for medical services related to their domestic violence or counseling. So something that, could be covered elsewhere, but if they don't want to have to provide that background information to their employer. And then the same goes for pay as well. So it's kind of a theme of what laws are generally available for health conditions, for disabilities. There can be ways to avoid disclosing if that's a really serious concern for somebody, but it depends on the situation, the diagnosis, and the particular laws.
Yeah, and I'm noticing we're almost out of time, though I want to highlight that Katie's provided some examples here that if we had more time, we were going to walk through with all of you. But I do see that we've got like 1 minute left, so maybe we'll go to the resource slide. And then we do have one question about unemployment insurance, and she wanted to ask if it applies to all the states. So as of today, 42 states, I can't believe again I've memorized this, 42 states and the District of Columbia have amended their unemployment insurance codes to clarify eligibility for unemployment insurance for victims of domestic violence. And some of those jurisdictions, and I can provide this detail to you if you want after the call, some also include sexual assault victims, and some also include stalking, right? But it varies, from jurisdiction to jurisdiction. Even the state of North Dakota has amended their unemployment insurance code in this manner. So it's not all the states, but it's almost all the states. But I also just want to say, really importantly, that even if you're in a state that hasn't amended their code, right, to clarify eligibility, it still may be possible, right? I litigated these cases, and I say litigate because it went beyond the administrative appeals process before these laws were all passed. And in Connecticut and in California and a variety of jurisdictions worked on these cases. And depending upon what establishes good cause, right? So this gets into some detail we can't really do here, but it has to do with the requirements to be eligible for unemployment insurance benefits and to qualify. And you have to establish, that, and I just want to say this, there's a lot of misinformation about unemployment insurance benefits. It says, if you quit your job, you're not eligible. That's not true. It has to do whether or not you had good cause. And there's all this misinformation out there that if you were fired from your job, that you don't get UI. And that's not true either. It depends on why, right? And so I would just urge those of you who are interested in this area of law, you can follow up with me, but also to kind of dig a little deeper. And I know many survivors who were able to get out of abusive relationships because they were able to access unemployment insurance benefits. It's not the lottery, but it's over 300, can be up to $300, $350 a week for up to 26 and in some jurisdictions even longer weeks. And that can be the income that a survivor and her family needs to relocate. So never underestimate these income supports that Katie's talking about. And then this last slide highlights some resources that we've alluded to throughout the call. and including Workplaces Respond. This is actually Futures Without Violence. They have phenomenal materials for employees, but also importantly for employers. Some really dynamite materials for employers. And so if those of you on the call who work with employers or represent employers, there's great model policies there on not just domestic violence and sexual harassment, but sexual violence and sexual assault, and they've combined them, right? And not just policies. Recognize, Me Too has really highlighted for us that we need to go beyond having a really good policy, right? We need to go beyond the 1 hour annual sexual harassment video training. Like, clearly none of this is working because we still have rampant rates of sexual harassment and sexual violence in the workplace. So that's a great resource. Legal Momentum's website, and this link I've alluded to several times, they have Know Your Rights fact sheets, and they also have state law fact sheets that list all the states that have the laws and the links to those statutes. And then the last one is Katie's great website at Legal Aid at Work, and they have great fact sheets as well. I'll let you describe those in more detail.
Yeah, it's generally worker focused, but we have a helpline for people who are experiencing domestic violence at work if they want more information about their rights, and tools that help explain, how all of these different protections fit together. A lot of it's California focused, but some of it might be generally applicable too.
Yeah. Well, thank you all for hanging with us throughout this. And we couldn't do it all, but we were just trying to start a conversation and start people thinking and raising awareness about all of these laws and protections that exist around the country for victims of domestic violence, sexual assault, stalking in the workplace, and see the links between those and sexual harassment and what we've learned about what sexual harassment is and what people are experiencing in the workplace that they need protections for. Again, I just want to make sure everybody understands that there are some great handouts available in the box that you can download right now, including these slides. And then Paula's going to make these available on the Center, on the Civil Rights and Social Justice section's website. So please feel free to send people to that if you thought this was helpful. You also will get an email that has a link to that recording, so you can just forward that on to others who you think could benefit from this. We really hope that you found this informative and helpful. And again, our email addresses are not here, but you can get that information from the ABA from Paula. And I just really need to give a shout out to Paula and the staff at the ABA and the Civil Rights and Social Justice section. If you like this, if you like the 6-part series that we've done on this, it would not have happened at all, no way, no how, without Paula and Allie and everybody there. And I just want to thank and recognize them for putting this together and making it possible. Katie, anything you want to say? I
think you covered it. Thanks.
Well, thank you for doing this. We really appreciate it. And, there are not a lot of lawyers handling these cases. And so we're very fortunate to have Katie with us, because the experience that she's brought to this is from actually using these statutes or trying to use them, I guess, to make them work. And so that expertise was really valuable for today's discussion. So thank you for taking the time.
Thank you.
Okay. I think that's it. Paula?